The first mistake that most people, or things you should know in order to stay out of jail, is creatively structuring your real estate syndication to avoid securities laws. The second thing to understand in order to stay out of jail is to make sure that you understand that the SEC has a zero tolerance policy when it comes to advertising and general soliciting, specifically when it comes to social media advertising. Number three, people need to figure out, of course, that you cannot pay capital raisers unless they are licensed. Number four is just understanding what constitutes a substantive relationship. The last thing you've got to realize, and it's kind of one of my pet peeves, and the way I enumerated number five was just don't use someone else's PPM template. Welcome back to Real Estate Syndicator Live, episode 16. Really looking forward to this. The 5 things every syndicator must know to stay out of jail. Couple quick announcements. I don't know if anybody's going to be in the that Limitless event in Scottsdale this weekend. Just drop me a note in the chat. I'll be. I think I'm hosting a panel on Friday at 4:30 on capital raising with Brandon Turner and AJ Osborne, and really looking forward to that. And then we're going to have Brandon actually join us in a couple weeks. So 2 weeks from today, I think that's the 22nd. Brandon Turner, formerly of Bigger Pockets, will be joining us and giving us some value on how he's doing on his raising capital journey, which he's really crushing it. So that should be fun. So today we are going to talk about the 5 things every syndicator must know to stay out of jail. As I mentioned in my post, I don't know if you guys saw my Facebook post or what have you, and I mentioned it at the beginning of my ebook. You know, the odds are you're not going to go to jail. I want to be upfront about that, obviously. So the reason I picked that title, though, I did that on purpose, and it's not just a marketing gimmick or anything. It was obviously to get people's attention, but I think a lot of people just simply don't take securities laws as seriously as I think they should. And that has to do primarily with, I think, the prevailing, I don't want to say attitude, but the prevailing thought that, look, everybody's doing it. Everybody's violating securities laws. So if everybody does it, I'm going to do it. And they're not super concerned for some reason. Maybe they feel a little bit more confident in the violations by group. And so, hey, if everyone's doing it, what are the odds of me getting caught? But as I mentioned, you know, jail is definitely possible. I mean, just ask Bernie Madoff. And obviously, if you're in the business of defrauding your investors on purpose, you know, if it's intentional, you're definitely going to have some criminal issues. But most likely, the violations or the remedies that they're going to seek for you are still pretty serious, right? So they're still going to look at the main one, which is restitution, which means that you're going to have to return all of your investors' money plus interest, regardless of whether it was your fault or not. So you could think of the 2008 crisis, you know, that's, you know, you may have bought some property, syndicated a deal in 07, 08. The market collapses. It's no fault of your own. It's, you know, credit market freezes. It's called the great financial or the global financial crisis, whichever one you want to call it, for a reason. So you didn't really breach your duty as a manager. You didn't do necessarily anything wrong that caused the loss of investment to the investors. But if you did not comply with securities laws, you are going to be on the hook for a violation of the securities laws, most likely having what we call an unregistered offering. Because if you weren't able to comply with one of the exemptions, then you don't have an exemption to rely on. And so you have an unregistered offering. And that's where the restitution comes in, which is all of the money back from the investors plus interest, which most likely you won't have. I mean, if you raise 3, 4, 5 million and you lost all that money, you know, maybe you've got a war chest that you can go repay that money, but most likely you don't, which means that you will most likely be looking for bankruptcy protection. So that usually leads to bankruptcy. And then without a doubt, you will be barred from raising capital. Now, is that a lifetime ban? Is that a 5-year ban? Who knows? But you'll definitely be, depending on what you negotiate with the SEC at that point, you know, that's going to be another factor. And of course, the hit to your reputation, right? I mean, people are going to Google you in the future and see what Google has to say about you. And if you're nailed there with a securities violation, it's going to be very difficult for you to raise capital. Not to mention, you're probably at that point, not probably, you're going to be considered a bad actor if we can't negotiate that away. So that might be causing all types of issues. So anyway, the bottom line is, my point was, it's not good to violate. There are some serious consequences, even though it might not be you in a yellow jumpsuit. But that's the reason for sort of the title that I picked. But the fun thing today is, and I'm going to kind of fly through these a little bit. I wanted to kind of maybe more of a checklist today, because as you'll notice, if you haven't read the book yet, what we've been talking about over the past 15 episodes or so of this live is basically what these 5 things are. So let's just start with number 1. But the number one, or the first mistake that most people, or things you should know in order to stay out of jail, is creatively structuring your real estate syndication to avoid securities laws. So creatively structuring your deal, as you've probably heard me say before, the structure itself doesn't matter. And especially seasoned investors tend to get creative, right? They think they've come up with some really creative way of structuring something so that they don't have to register their securities. For example, hey, we talked about joint ventures, I think, in one of the episodes. So, hey, I'm going to call this a joint venture so I don't have to register with the SEC, or it's not considered a security. So let me structure it this way and kind of outsmart the regulators. Or maybe, hey, I'm trying to bring in some money, but obviously I can't do that. So let's just set up a consulting agreement or a marketing agreement so I can pay this person something. The other day, I heard somebody wanting to pay like a due diligence fee. And again, the structure, what you call a fee or what you call a securities offering, at the end of the day, the SEC is going to look straight through that. And they're just, at the end of the day, if there's somebody who's doing all the work, right, the definition of a security, if the returns are being generated by your efforts, it's a security. And the seasoned investors get caught in that, in the sense that they try and get creative. And then the new syndicators that haven't syndicated before, or maybe don't even think they're syndicating, is they just don't realize, right? They don't realize that what they're doing is a securities offering. So they, especially if they're just raising $200,000-300,000 grand and they're going to go buy real estate, they don't even think about the securities laws, and they don't realize that what they're doing is a security. And so it's important to understand really the structure itself doesn't matter, just because it's a loan, just because it's a couple of your buddies, just because you're trying to structure it as a TIC agreement, just because you want to do it as a loan, for example, is another one that happens quite a bit. The structure itself doesn't matter. The ultimate criteria is, are you accepting monies from passive investors where the returns are being generated by your efforts? And if you are, it's a security. And as we know, if you're selling securities, you either have to register the security with the SEC, find an exemption, or it's illegal. And if you're blowing one of these exemptions, then what you end up with is an unregistered offering, because you've not registered and you can't find an exemption. So anyway, so that's kind of number one. The second one has to do with advertising. I mean, you got to know the second thing to understand in order to stay out of jail is to make sure that you understand that the SEC has a zero tolerance policy when it comes to advertising and general soliciting, specifically when it comes to social media advertising. And so this is another mistake that I see too many people make. And again, this is probably a prime example of the, I don't say excuse, but the response that, hey, look, everybody's doing it. If they're doing it, why can't I do it? And that is posting your offering or conditioning the market or doing whatever on social media. And when I say social media, I mean social media, I mean podcasts, I mean your website, I mean anything that's obviously public. And I know we did, I think the second or third episode was on social media advertising. But again, if you put something on social media, that's going to be considered advertising if you're talking about your specific deal. So there's always things that we know you can do on social media, things we know you cannot do on social media, and things that are very gray, which I prefer to stay away. Things you can always do, we've been talking about this lately as well, you can always post about you and your company. So it's almost like a resume, what your company values are, what you guys are doing, what your investment thesis is, what markets you like. You can always talk about that. And then you can always obviously talk about value add, always putting in, nothing wrong with putting together that report about why real estate's the greatest, wealth creation vehicle of all times, or why, whatever, I was going to say California, but that's not a good example. Tampa, Florida, Dallas, Texas, whatever is the best real estate or the hottest market, or even a list. Hey, here are the top 10 hottest markets or the markets to watch. And nothing wrong with putting value add content. What you cannot do, obviously, is talk about your deal specifically, which I usually say that's kind of obvious, but I should have probably brought it up. I would have liked, well, I don't know if I should share it because I don't have it blurred out, but I literally saw a post the other day where they were specifically talking about raising capital for a specific deal, and it was open to accredited investors, to non-accredited investors. And literally said it's a 506B deal, so not even a Reg A. So there are people that are actually posting specifically about the raise on social media. And again, I don't know if they're just not realizing that that's violating, or they just figure it, hey, everybody's doing it, or I'm not going to get caught. But the bigger one, of course, is the conditioning the market, which is probably the hardest one to really, it's very nebulous, as you guys know, and it's very hard to pinpoint. But anything that drums up interest about your deal, even if you don't specifically talk about it. So, past returns are a great example, or when you're doing your due diligence trips and you're talking about what you're doing there for the day, and inevitably it's clear that you are in the middle of a raise, or maybe you even put in the hashtags, ask me about the deal, or here's a link to reach out to me or something. So conditioning the market is a big one, but it's so nebulous that as you guys, I think by this time know, that my recommendation is usually that if you have an active deal, just stay off of social media. It's really difficult. Almost anything that you post could be arguable as a conditioning the market. And if a regulator really wants to go after you, they can make any argument they want. And so I think if you have an active deal, you stay off social media. And if you are in between deals, that's when you do all the stuff that we talked about adding value and put together, webinars and blogs and reports. And, why do you think people start podcasts? Because that's just a way to add value. So that's the second thing. The SEC has zero value or zero tolerance for violation of securities laws. Number three, people need to figure out, of course, that you cannot pay capital raisers unless they are licensed. That's the other big one. Even today, I had a conversation with someone who was trying to figure out how to do that. But as we all know, you cannot pay somebody to raise capital for you unless they're a licensed broker dealer. And by that, I mean an SEC or actually a FINRA licensed broker dealer, not a real estate brokerage, but then actually an SEC license, just like you. I need a license to practice law. Doctors need a medical license in order to go raise capital. They do a thing. And again, as I mentioned earlier, the structure itself doesn't matter, because calling it a marketing agreement, calling it a consulting agreement, calling it insert here agreement or fee doesn't matter. They're going to look straight through that. They're going to see, did you actually do any of that work? If it's a consulting agreement, they're going to see what your level of expertise is. Did you have phone calls? Do you have minutes of those meetings? Do you have notes? I mean, you're going to have to show that you actually truly did consulting for this company, and that you can document, and that whatever fee you were charging, whether it's hourly or flat, is commensurate with that amount of work. Just simply calling it that and having, actually most people don't even have a consulting agreement or a marketing agreement anyway, but just calling it that doesn't matter. And so you've got to make sure that you can't pay the capital raises, and it all comes down to primarily paying somebody transaction-based compensation, right? Cannot pay somebody transaction-based compensation. So, hey, if you raise X amount of money, I'm going to give you 5% of the GP. Or if you raise this much money, I'm going to give you 10% of the GP, or I'll pay you a commission or, a fee. Can't do that. And even if you're not paying them a transaction-based compensation, that doesn't get you out, off the hook, doesn't get you out of the hot waters, because you still must be doing what we call substantial work, substantial duties for the syndicator. And your primary role needs to be those substantial duties. You've got to spend more time working on those substantial duties than you do actually raising the capital. The raising capital almost has to be incidental to your other duties. And just like we just talked about, what is conditioning the market, what is substantial duties is very nebulous as well. And it's kind of hard to do. Most people try and jam in an investor relations kind of role, and that may or may not work. We've heard some rumblings that alone is not going to cut it. But as we've talked about, I forget what episode it was, there are investor relations and there are investor relations. There are people who simply don't do too much and just forward emails. Somebody puts together a report and they just basically forward it on and don't do much more. And they raise a ton of money for the company. And there are other people who do a lot more, and they're really involved, and they're trying to figure out the return. They're putting up the quarterly reports and preparing those and sending them out and fielding all the questions themselves. And maybe they incidentally bring just a little bit of cash. And so that might be better. But this capital raises thing, as you guys have heard from me, and I think many of my colleagues say, it's really getting out of hand, and really getting a little concerned about that when the market either turns or flattens, or when a lot of these properties that are being bought a little bit on the high side that are really depending on rents to continue to rise, which they are obviously, or that are dependent on the cap rates not going up too much. That's when you're going to have some issues. So number three is always the capital raising thing. Number four is just understanding what constitutes a substantive relationship and a pre-existing substantive relationship. That's another issue that comes up a lot of times, where people, look, it happens to me all the time on the reverse side, which is, people go to these conferences, man, and they go to the conferences and they gather all the business cards and they get into these conversations, which is great. And then the next thing you know, there's an email blast, offering them a deal. And the reason I know that is because I get that all the time, even though I've cut back a little bit on my seminar attendance these days. But, I pass out my business card just like everybody else. And people forget, I guess, that I'm passing my business card in my capacity as a vendor or somebody that can help them professionally. And 3 weeks later, I get an email from somebody I don't even remember talking to be frank, and it's offering me a deal. And so we clearly don't have a substantive relationship. and I'm getting deal that. And so that's something that pops up a lot. And that really gets you into hot waters, because if you don't have a pre-existing substantive relationship and you met them at a seminar, you are, how do they find out about you? Most likely it's a general solicitation or it's an advertising, and therefore that would blow your 506B exemption, which then reverts everything back to, well, what you have now is an unregistered offering. Like you've got to either register it, you have to find an exemption. If you can't do 506B, what's your exemption and what's your registration? So that really causes a lot of issues. One of the things I promised to do is, see if I can do this without getting too, I'm going to share my screen here with you guys. And I know a lot of people listen to this, so may not see it, but here's the questionnaire. I always talk about the questionnaire because it's one of the top, there's approximately 8 steps that you want to go through in order to take somebody that you don't really know, who's a complete stranger, and get them into this position where you have a substantive relationship with them. And the top 2 are always sending them out this questionnaire, a detailed questionnaire, not just what's your name and phone number and favorite color, but a little bit more in depth. And then also having a phone call with them, right? Some kind of an interaction to probably go through the questionnaire a little bit and find out information about them, and they can find out information about you. And generally you're fostering that relationship. And the questionnaire, there was a questionnaire, I should still call this a Citizen VC questionnaire, but this is not the Citizen VC questionnaire, because that doesn't exist anymore. It used to be on their website, and now their website is just static. And so I just decided to put my own little questionnaire here, and I'll make this accessible to everyone. You can either, well, I think I posted it today on the Facebook group, I believe. So, but if you need a copy, you can either just reach out to me, or I think it's still automated if you email jail@premierlawgroup.net, jail@premierlawgroup.net. I believe that also just automatically sends you the whole ebook, actually, but this is the attachment to the ebook. But as you can see, it's, obviously you want to get their information, their occupation, but then, what's their current investment status, right? Are they investing in, do they have experience investing in real estate, stocks, bonds, precious metals, Bitcoin? Are they running a business? What is their level of experience? What are their overall, investment goals? This is something, I always analogize this to the application or the questionnaire that you provide when you are applying for a margin account at a brokerage firm, or you want to, trade options. These are the types of questions you get. What are your overall investment goals? Are you looking for cash flow, appreciation, preservation of capital, tax mitigation? Because obviously all of that information is relevant for you to determine whether your investment is going to be suitable for this prospective investor. If you've got a deal that's not going to cash flow for 3 years because it's a ground up development, maybe that's not a good fit for this individual. If somebody's 99 years old and on a retirement thing, maybe appreciation is not as important as preservation of capital. So this helps you identify what their goals are. What's their risk tolerance? Again, that usually has to do with age. Are they highly aggressive? Are they somewhat aggressive, moderate, conservative? So you want to know that. How much investments do they have? That'll also tell you a little bit about their experience. Do they have a lot of money invested or a little? And if they have investments, what type? And then specifically, PPMs, syndications. How many syndications have they done before? Is this the first one? They've never done it. They don't really know how it works. They don't understand, what exactly is going on, or do they do that a lot? And then obviously you want to know if they're accredited or not. And so usually we want to have a link there to help them with the accreditation status. If you've had this questionnaire before, you obviously may want to update the link, since the accreditation was updated last year, and include a couple more people. And then the other stuff that I think you guys is more common, what's your net worth, what's your income? Those are things you want to know. Even if they're not accredited, you want to make sure you're not taking all of their money, right? There's no law around this, but generally speaking, maybe 25% of their net worth is something you should probably be, careful about, in terms of if they're non-accredited, you don't want to be taking their last penny. So maybe 25. So this is a good way to estimate, how much net worth they have, and then how liquid they are. And then obviously, when do they need the money back? Some people, need to have their money back in 1 or 2 years. And if yours is a 5 to 7 year hold, or a 7 to 10 year hold, and then whatever else they think that is makes sense for them to share with you. So happy to, like I said, if you're not part of the Facebook group, I posted it there today, and I'll maybe when the first question comes in, I'll put that info in the chat. But oh, great, Johannes, I see that you, and I keep butchering your name, buddy, but thank you. I think the link there is on for the thing. Yeah. Oh no, I was like, it was somebody. Oh, a couple of people have posted. No, it wasn't you, John. I know you're. I've got a couple of people posted. So I appreciate that. All right. So that's kind of the fourth thing. And then the last one, which is, interchangeable a little bit, but the last thing you've got to realize, and it's kind of one of my pet peeves, and the way I enumerated number 5 was just don't use someone else's PPM template. That was kind of it's one of my big pet peeves. I literally had before I wrote this, I literally had a call with somebody we were doing a consultation before they never became a client. And they had taken one of my templates that I had presented at a seminar, which is just literally a template I got from the internet, just to show people what a PPM looks like so they can have a feel for it. And he took this PPM and just changed the stuff. And that was the PPM he used to go raise $600,000, I think it was. And the PPM is just a conduit, right? It's just a pipeline, and that you just have to fill, right? That pipeline or that conduit, you need to fill that with your specific details, your specific risks, your specific disclosures. There are a million PPMs that you can get off the internet, but it's a pet peeve of mine because people always call me and they're like, hey, we just need the PPM. We just need the docs. And it's like, no, what you really need is the compliance. You want to make sure that you're raising the capital in full compliance with federal and state securities laws. You want to make sure that whatever relationships you have, that you're not paying them inappropriately, that whatever you're posting on social media is not appropriate. And, we have a million things in our bag of tricks that, in any given deal will get triggered and say, oh, wait a minute, that we need to look into that. And so just make sure that, doesn't have to be me, but just make sure that whoever you're using, that this is something that they're an expert in and that they can actually craft a PPM and disclosure documents that are specific to your specific risks on the market, your specific risk on the property, your specific risk on the loan product, and your specific risk of the membership or sponsorship team. So anyway, that's kind of my 5 things every syndicator must know. As you can tell, it's sort of like a summary of what we've kind of talked about in most of our first 15 episodes, but I wanted to give a little bit of a summary. And again, the idea here is not to scare anyone. And in fact, when I send out the ebook to everyone, you'll see that in each of these chapters, I not only tell you what the issues are, but I also have a little section of kind of my recommendations of actually how to do it. So if you're going to do a joint venture, for example, I have a little box that tells you, here's how you should do a proper joint venture. This is how you should do a proper this. This is how you should do a proper that. So it's not meant to scare you, but it is meant to grab your attention, because I do want to stress upon everyone that, these are serious. Securities laws are complicated and they're serious, even though sometimes we make them seem a little bit easy and they seem repetitive. But I just want to make sure that everybody is compliant, maybe not worrying about going to jail. But anyway, hopefully that was helpful. A little bit longer than I thought. I know I could probably speak for a couple hours, and I was trying to rush through that because I didn't want to spend all the time on that little presentation. And I wanted to make sure I was opening it up for your questions on this topic or any other topic. So without further ado, I'm going to go through these. Bethany's not with me today. She's actually getting ready to hop on a plane and go to Europe or something for a little while. So we're going to miss her for the next week or so. But let me go through, see if you've got any specific questions. I'll go on the chat first, and then I'll just open it up there. But Dan, thanks for the comment there. They're not as ambiguous as I am. If you get big enough, they'll come looking. That's why I'm so careful to be compliant. Yes, great. Michelle, that phrase, everybody else is doing it. That is case. All right, Michael, sorry, I missed number 1. Did you say people cannot loan you money without registering with the SEC? Okay, let's talk about that. So Michael, why don't you read your question? It's not number 1, but it's a good question that we should address.
Hi, Mauricio. Did you say that people cannot loan you money without registering with the SEC, as in having a note and mortgage? I've seen that a lot, where people loan money, balloon note 1 year, something like that.
Yep. Yeah, that's a great question. And I've been meaning to do an article, or actually more of a detailed blog on notes, because notes are not as simple as we want them to be. They're not as black and white as we want them to be. And literally the case law on notes literally says something to the effect of, look, if it looks like a security and it quacks like a security and it walks like a security, it's probably a security. That's kind of the level we're at. But let's go back, and I want to address it. That's a great question. So first and foremost, the general rule is that a loan, which is a promissory note, is a security. You should start with that assumption, because if you look at the definition of a security, I think it's the second one on there. It's a note, right? So equity is a security, note, bonds. I mean, those are securities, right? Now, so the general rule starts with that. Now, there are situations, there's about 5 or 6 things, for lack of better elements, that if you can show one of those 5 or 6, for example, a mortgage, right? If you get a mortgage, if I lend you, even if it's a private party, if I lend you money so that you can go buy a personal residence and you secure my loan in first position with a mortgage, that is technically it's a security, but you kind of rebutted the presumption that it's a security because that's one of the 5 elements of that thing. If it's a loan to, that's just sort of for accounts receivables and things like that, that would also not count. But generally speaking, it's got to be one of those 5, or what we call a family resemblance test, which means if it's close to that. And so in our world, the close that I'm comfortable with is if you do a loan that is secured in first position on real estate, I think you're going to be okay in that scenario. But the minute you start fractionalizing that note where you have, you're really raising capital that way and you're going to get a loan, let's say you need to raise $1 million. If you got one person to write you $1 million check, you secure it with real estate, that might fly. If you get 10 people at 100 grand, now you're fractionalizing that note, that becomes an investment contract, which is a security. So a lot of people have the mistaken belief that because they do loans instead of equity, that somehow that changes things. And the reality, it doesn't. You should always assume that just because you're doing loans. Now, the one exception to that, and the one definition that is clearly not a security, is if it's a loan that's less than 9 months. So if I give you a note and it's, 8 months or whatever, and I pay you, interest and principal, and it's all done in 9 months, that by definition is not a security. I think a lot of that probably works best for flippers. So if you're buying and rehabbing homes, and typically those flip in 3, 4, 5, 6 months, and again, it's one investor per property, that kind of stuff, then that's fine. But otherwise, it's going to be security. So that could be, like I said, a whole, and we will do that. I think once I do my deep dive on and get a little bit more, be able to outline it in a clear way, we'll do an episode on just notes, because it does get a little bit tricky on what exactly is a note. But the idea that because it's a note, somehow it's not a security, that definitely is not something you want to do. Thank you, Michael. Good seeing you. Ludi, hi, how are you? Cameron. Do you want to read your question, Cameron Barnes? Unmute yourself. Otherwise, I'll read it. Question from
sorry, I was on mute. I was in the middle of
no worries. Go ahead.
Burning myself. So from the description, I know it was just brief, but from the description, it sounded like the position of somebody on your GP team that's capital raiser is not actually a valid position. Like you're going to break the rules unless that person is actually registered with the SEC to do so.
Yeah, that's a great question. You want to get the term capital raiser almost out of your vocabulary. You certainly do not want to have, emails going back and forth, or, spreadsheets that show capital raisers getting 5%, or negotiations about that back and forth on email. One of the things that I like to stress is that if things go south and the regulator opens up an audit and they're actually looking into something, several years down the road, the email communications between all the sponsors, the spreadsheets that everybody throws around and communicates with each other, those are not privileged. And so when the regulator, whether it's an SEC or a state regulator, will subpoena those records, they'll say, hey, send me every single email that each sponsor has sent to each other. Send me every single document you've prepared. Send me everything. And you're trying to argue, no, this is not a capital raiser. They were doing this, they were doing that. And you have a string of emails going back and forth where somebody said, hey, I can raise a bunch of money for you. I'll give you 5%. No, I want 8%. And you start negotiating, and that's all in an email. Then that's going to be problematic, because, that's going to be a clear violation. So I would eliminate that. Bethany's even harder than I am on this, where she's just get that out of your vocabulary. They're not capital raisers. They're co-sponsors, right? They're helping you in the deal. They're doing everything, not everything, but they're doing things like you. They're doing the due diligence. They're doing the market research. They're doing the underwriting. They're talking to the lawyers. They're talking to the CPAs. They're raising the capital, which is part of that. They're doing all the asset management. They're having meetings, all of that stuff. They're doing their investor relations. They're doing stuff like that. So they're your partners. They're your co-sponsors. They're your co-GPs. They're not your money raisers. So anyway, I don't know if I beat that one to death, but that's a great question. Before I go on, I apologize, Michelle. I apologize. You were actually one of the folks that submitted questions ahead of time, so I wanted to go back to you. Are you on? If not, I can read them. But I thought you had great questions about the third-party verification updates, which apparently there's been. I did a post on that a couple of days ago, and it's also creating some. Actually, somebody else also. I did a post because somebody actually posted it, and I thought it was an interesting topic. Michelle, you want to ask your question?
Yeah, I'm here. Thank you. So my question is, can you accept a third-party verification letter from an investor that was used in somebody else's fund and apply that to your current syndication as, you know, your due diligence and saying that they're an accredited investor, even though you did not physically, you know, say you use, you know, one of the third-party services, you didn't personally do that. You just took a letter that the investor gave you that they used somewhere else.
Yeah, I think that's a great question. So the rule got updated when they updated all the, when they did the 506B to 506C update, when they updated the accreditation rule and the integration rules, they also updated the verification because it was becoming a pain for us, for serial capital raisers or serial syndicators who were doing, you know, 2, 3, 4, 5 deals every year or every couple of years or just numerous. And the same investor, you had to, you know, you got the verification for the investor, and then they came back 6 months later and you have another deal. And then you had to like re-verify them, you know, every time. So every month or every couple months, or it was just becoming logistically not something very efficient. And so what the SEC said, and when the original rule came out, they said, look, this is good for 90 days, right? So after 90 days, you had to keep getting new verification documents from your investors. And what the SEC said is like, okay, great. I know that's kind of a pain, so let's update this. And it's the same exact verification process that we had before. So you still have to either get the CPA verification letter. I think sometimes you get an attorney verification letter, or you're getting tax, or whatever method of verification on the safe harbor side that you're doing, that has to stay the same. But now once you get them verified, you don't have to keep updating that verification every time you do a syndication. That's going to be good for 5 years now from the date you originally got that that approval or that verification, as long as they can then self-certify that, hey, since the last time you did this verification on me, there's nothing's changed. I'm still accredited. I'm still whatever. That's the rule. Now, it only applies when you're the issuer, which the issue is like issuer. Sometimes, again, if you're looking really technical, the issue is always a syndication LLC, and you're always going to have a new syndication LLC every time. So it's not technically exactly the issuer. It's the, you know, you as the sponsor, right? So if you're doing this, another syndication next time, you're going to technically have a separate issuer, but it's really still your syndication LLC. So you're the one, in order to comply with that particular provision, you're the one that's going to have verified the person originally. The idea, again, is just so you don't have to re-verify the same person over and over and over again. So for that safe harbor, you cannot take an accreditation that, you know, let's say Mauricio did a syndication 6 months ago and I verified John, and now John takes my verification and goes to you and gives them that verification. You wouldn't be able to rely on that under the safe harbor. And maybe I should back up a little bit and remind everyone, or maybe you guys didn't know, but whenever we talk about the verification progress, we always go with the safe harbor, because again, we always like safe harbors, right? Because it means we comply with that. There's no room for interpretation. So the CPA verification letter, or the tax returns, or the W-2s, or whatever, that's the safe harbor, meaning and that has to be exact. The other way you can verify somebody is on this reasonable belief, where you have to take reasonable steps to verify, but it doesn't necessarily, it doesn't have to be one of those things. And so it is theoretically possible. And I would use this as a backstop. I would not rely on this primarily, but if you ended up doing that, or maybe you just didn't do a proper verification, you know, can you take a verification letter from a different person? And if you've got a pre-existing relationship with them, you know them really well, and you know the sponsor over there, you might be able to pull off on the non-safe harbor, on sort of this reasonable thing over here, that verification method, maybe, but I would certainly not rely on that myself. That would not be my number one. I would always want to rely on the safe harbor, and under the safe harbor, that does not cut it. You have to verify the investor yourself. If for whatever reason, and I've had clients that just haven't done a good job verifying, and so you kind of failed that process and you're looking for a backstop, we might be able to argue that, hey, look, I've got a verification from another issuer, and so that, that might cut it. But I think for our purposes, what I would tell you is I would definitely not recommend relying on a verification letter that they give you from a different sponsor. This is really meant to, the crux of this was meant to avoid having you have to just re-verify the investor time and time again when they're in your second deal, third deal, fourth deal, and fifth deal.
Okay, so then the attestation letter, if I have the same investor to, fund 2, and then they want to invest in fund 3, the initial verification letter that I did is good for 5 years, but my understanding through our conversations is that if they invest again, I need to get some sort of attestation from them that their status hasn't changed, whatever they were claiming, either income or net worth. Is that correct?
Correct. And that can be an email. It doesn't have to be like a,
Okay.
it's not a what's it right? You use the word attestation, which is kind of a legal term, or it doesn't have to be notarized. It literally could be an email and say, hey, Michelle, I just want you to know that, nothing has changed since my last letter from 3 years ago. I'm still making more than 200 grand. I'm still, a net worth. We actually now have that box in our questionnaire where we just, they kind of they check the box. Hey, I'm accredited and it hasn't changed. I previously submitted a verification and my status hasn't changed. So it can be as simple as an email, but you want to have it in writing somewhere.
Okay, perfect. Thank you so much.
Of course. And then I think your last question, which I think I answered, which is what are the SEC consequences if you do not follow the process? And that's where the issue becomes is you're no longer, if you don't verify your investors, you cannot rely on 506C exemption. So then you revert back to having an unregistered offering. And the question is, what's the exemption you relied upon? Because obviously you didn't register it. So now you're scrambling to find another exemption. And, maybe you're lucky enough where you even, I don't know how to say, maybe you didn't end up advertising or something. And so maybe you can fall back on 506B, or maybe there's some other thing you can fall back on. But that's the issue, is that you end up with an unregistered offering and you have all the consequences that we talked about earlier, which is if something goes wrong and you get sued, you're going to have to return. If you're found, liable for an unregistered offering, you're probably gonna have to at least return all the investors' money plus interest, and hopefully not have any other penalties and other consequences.
Great. Thanks so much, Mauricio.
Thanks, Michelle. Always good to see you. Thank you. Have fun in Belize. I'm gonna miss you guys. I don't know why I keep having a hard time with your Johannes, right?
Yes.
Yes. Good.
Honest, yeah.
Good question. Why don't you ask about filling out the questionnaire?
So the question is, do they have to personally fill that out, either an email or maybe something like Active Campaign or an investor portal, or is it something that we can go over on either a call or in person and then actually feed it into our system on the back end, but we have the information?
I think that's fine. I mean, I think if you have that phone call and you decide to go through it manually and go through one for one, and it's almost like you're doing an interview style and you're checking the boxes and putting them in there. I think that's fine, especially if you make a note that that's the mechanism you use. There's nothing that specifically says, they've got to fill it out. Or it's got to be in ink or whatever. So I don't have a problem with that. That's fine. And I appreciate the link. Is that, I don't even know that. Is that the link? Is that a legit link? PremierLog.net.
I think, yeah, that's your link. Stay out of jail.
Great. Perfect. If that doesn't work, I'll post it right here. It's do everything here. Everyone, if you email, I actually have the URL, stayoutofjail.com, but I haven't used it. PremierLawGroup.net. Or if you want to see the Facebook group, I'm going to do mauriciorauld.com/Facebook group, because I'm always posting it on there as well. So I think that's it. All right. Sorry about that. Let's go back up here. Oops, sorry. Wow, all the way up here. All right, thanks for posting that. Christian in Los Angeles. You want to unmute yourself? You're still muted. I don't know where you are if you're still here. I'll just read it. So Christian in Los Angeles says, here in California for small deals, 10 units or less, doing a deal now where the funding partner wants 50% of the share. Yeah. So the funding partner, which also means capital raiser. So the funding partner wants 50% share of the LLC, bringing in all the funds. And for us, the GP for the sweat equity. This is not, et cetera. This is not a syndication. How to structure this. He is my friend of 10 years. So that is a syndication. So, anytime you bring in investors where the returns are generated by your efforts. So if that person's just giving you all of 50% of the money and getting, or whatever the percentages are, that's just like having a one-person syndication, right? I mean, that doesn't make too much sense, because if there's only one other person, there's probably a way to, the way I would structure that is I would actually make that a joint venture. because it's easy to do. All you need to do is make them a co-manager. So that way they're having to make all the, all the decisions of the company. So they're going to, they're actively involved if they're the co-managers. So with one other person, it's fairly simple. Now, a lot of times they don't want to have involvement. So they literally want to write you a check and not be involved. And if that's the case, and that's problematic because that is now a syndication, you've got to do it. But if they are up for it, that's the way you get around it. But just because they're one person, if you have an LP GP structure, whether it's one LP or 100 LPs, that's going to be a syndication. He's my friend of 10 years. That's great. There's no friend exception. What exception is this? Or just given our shares of the LLC, he's just simply thinking of creating an LLC and specified carve-outs. Yeah. So again, I would probably structure this where it's just, you just draft an operating agreement and you're both co-managers and co-members. And as long as, every time there's a decision that's being made, he's got the voting rights and he's actually signing the written consent, I think that's going to be just fine. It's exemption. It's going to be probably a 506B because, he's been friends with you for 10 years. You probably are not advertising this deal to one person. So you probably have an existing relationship, pre-existing relationship, substantive relationship. So that looks to me like a 506B. And if that person's accredited, makes it even easier because you don't actually have to give them a PPM if they're accredited. So as a reminder, a PPM is only required if you have non-accredited investors. That's the highest level of disclosures. Every single person you have is an accredited investor. You can get away with not doing the full-blown private placement memorandum. You still want to have disclosure documents because you want to make sure that every statement is complete and you're not omitting material facts. But with one person, it makes life a lot easier. You can also do a loan. If you're going to do a loan, again, one person, one property, secured, you might be able to get away with a loan in that particular case. John, looks like a link is dead. Yeah, Facebook group. Thanks, John. I thought it was still good. Jail at Premier. Oh, because you misspelled Premier. Premier is PREMIER. Law group. I think it's still valid. It's jail at premierlaw.net. Ludi, okay, insufficient permission. You do not have the necessary permission for the specified page.
I think the extra long Facebook link doesn't work, but the other link for the group works.
Got it.
I just tried to get the straight download for the PDF, but that was only for my account.
Yeah.
The other two work.
Join the Facebook group. It's such an amazing group. Even today, there was somebody asking, or yesterday, a 1031 question, and like the whole community jumped in to answer the question. So it's the Real Estate Syndicator community on Facebook, and it should be mauriciorauld.com/FB group. Dan, go ahead, Dan. Ask. I may not know the answer just because that's not something we do, but let's take a crack at it.
Sure. Yeah. Well, I was blasting through Google search and I may have found my answer here. On LinkedIn, in the context of 506B, somebody was coming on and saying, oh, we should do Reg CF because of reasons. And I'm just going like, well, why aren't more people doing it? And part of what I see is there are 12-month limits based on a balance of annual income and net worth, whichever one seems to be bigger. Like I see somebody, it says here in this chart that if your income is 200 grand and your net worth is 900 grand, then your 12-month limit is only 20K. And so everybody I'm talking to, they're in commercial real estate syndications. So like a 20K buy-in is pretty rare. It usually tends to be like 50 to 100. And I see that with their calculations, I don't know why they chose these numbers. If you had an annual income of 1.2 million and a net worth of 2 million, then you'd be able to do 107. I'm suspicious that this is why they're not choosing this, why this hasn't caught on in the last year since it became a thing. But that's what my research says. Do you have?
Yeah, great question. So I wrote a report on this. I don't know if it's on my website. So if it's not on the premierlawgroup.net, just drop a comment on the Facebook group and I'll upload it or something. But the main reason I think prior to last year, I don't know if it's maybe 18 months ago now, is that there used to be a $1 million limit of how much you could, it was indexed to inflation. So maybe it was at that point, what, 1,032,000 or whatever the number is, but it's a kind of a low amount. I mean, maybe it works if you're trying to raise 300 grand or 400 grand, 600 grand, but most of us are raising more than $1 million. They recently upgraded that to, I want to say 3 million, maybe even higher. But so now that number's gone up, but here are the issues with regulated crowdfunding, which I think is why nobody's asked me to do one. And I really don't want to do one. Even though you can, first of all, you can't even really market it. I mean, there's some kind of tombstone high level. So you could say something like, hey, I'm raising $1 million to buy a 100-unit apartment building in Houston, Texas. And then you've got to put the link to whatever the platform is that you're using. And it's not your personal platform. It's got to be a broker dealer platform or what they call as a portal that's registered with the SEC. So you can't even put it on your own website. And you have to basically push everybody to that link. And then that's where the advertising happens. It's not like I can just do carte blanche blank marketing on my page. That's one issue. Then there was the limits of $1 million for every 12 months, which is another issue. And then, like you mentioned, the other issue is, even though you can take non-accredited investors, they're limited to, and you probably have it, it's been a while, I think it's $2,000 or 5% of their net worth or income, whichever is lowest. So in my report, I actually talked about scenarios, theoretically, that you could be you could be an accredited investor. You could be like a doctor making $210,000, but if you're got student loans, or I mean, there was just some wacky thing I came up with where you wouldn't even qualify. So you're right. You're just using small $500 investment. It's almost like Reg A sometimes. $500 investments, $1,000 investment, because it's 2%. Think about it. 5% means if I have net worth of $500,000, 5% of that is 25 grand, right? And if my income is $200,000, well, so it's, I think that was my example, actually. Like some of these CEOs, they're making $1, right? Their net worth is off the charts. But if you're earning $1 and your max is $2,000 or 5% of my income or net worth, whichever's lowest, so it's just a little fun. I think that's another reason it's getting caught up. Plus, if you're trying to do it, you've got some compliance. So if you're you set up a portal, there's a cost, obviously, so that's another issue. But depending on how much you're raising, you may have to be providing your audited financials. You may have to be providing, a CPA certification on your books. There's a lot of, it's kind of a pain, to be honest with you. And I think that's really ultimately the reason why it's just, yes, it's a little bit more expensive probably. Although I haven't done one, but I've heard that people who do regulated CFs are also charging in that 15K range. So it's not even a cheaper compliance thing. So I don't know. That's my 2 cents on it. We don't do them though.
That's great news. Thank you.
Thanks, Dan. Good to see you. Mark, co-sponsors equals managing members.
So Mauricio, I just had a question. I've heard GP, I've heard managing member, I've had co-sponsor, sponsor, and I'm like, are they all the same? Are they all different? Or
yeah,
I've heard someone said, don't use the word GP anymore. Go to managing member. I don't know. So is it just a little nuance, or?
Yeah, there's a little bit of nuance. So when I say well, in this case, neither one. You said co-sponsors management. So the GP is vernacular, because obviously most of us are doing LLCs anyway. So we don't have GPs and LPs. We have managers and we have members, right? So but I'm good with that. It doesn't matter. That's just vernacular. But when somebody says GP, generally speaking, they're talking about the sponsors or the co-sponsors. If there's multiple GPs, they're co-sponsors. That's what the GP is. Now, the GP really is that management entity. You said managing member. I wouldn't say that. It's the manager of the syndication. Now, who is the manager? Whatever that entity is, that technically is the GP. But in my world, and I realize not everybody does this, but this is just from my asset protection background, we separate the managing part from the membership part, right? So in a syndication, if you're doing an 80-20 split where you're keeping 20% as your carried interest or your sweat equity, I'm going to put that in a separate entity. It's going to be the Mark Holdings LLC that's going to own 20%, but your GP, the one that's actually the manager making all the decisions, is going to be Mark, Enterprises or some other entity. But you're right. They use it a lot interchangeably. Co-sponsors, I would say, is equal to GPs. And the GPs theoretically is anybody who is sort of actively involved, who are raising the capital and doing the deal, right? But it's a good question, because the challenge of the problem is everybody's using vernacular that isn't really even correct to begin with, and everybody just kind of assumes, well, what we really mean is this, which is fine, but then you have some of these misunderstandings. So co-sponsor to me is a GP. John, you may. John, you said, may I ask a question? Although I'm always nervous when I get questions from lawyers, but that's all right.
No, that's okay. I'm not a practicing lawyer, so I've been reading up on 506B, 506C, looking at the rules, and I understand exactly what they say, but I'm trying to wrap my head around why. So I get it. 200 grand or 300 grand married, 2 years expectation moving forward, or $1 million excluding personal residence net worth. But then from tonight, we're talking about, well, they used to be accredited, but now they're not. What is the reasoning behind this? Because, in other words, if I was accredited, if I was making the 200 grand for the last 5 years, but for this year and next year I won't, apparently the SEC thinks, oh, he's an idiot now. He was brilliant investor the last 5 years, but because he's making under 200 grand now and isn't going to make it next year, he's an idiot and he can't invest. So it seems like the money is just a proxy for, it isn't a proxy for intelligence. It's more of, oh, we don't care if this guy loses money because she has plenty of money. Do you understand what
I understand. Look, I mean, I wish Russ Gray was on. He'd come up with all of his conspiracy theories. But I mean, look, trying to figure out what Congress or the SEC is trying to do is I'm not even going to try. But the official explanation, I think, and I'm not trying to explain. That's the debate that's been going on for decades, which is net worth or income, is your financial situation really the correct mechanism that we should be using, which is one of the reasons why they're supposedly talking about expanding that and taking an exam, because a lot of people, as you mentioned, smart people don't make a lot of money, and the dumbest people in the world make a lot of money. I mean, they just wanted to say, look, it's really theoretically, the way I see it is like you just have to make 200 grand for the last 3 years, and they kind of change that to sort of 2 plus a half or whatever. But yeah, I think that's their position, is like, if you make a lot of money, you can afford to lose it, and so you don't need as much protection as the little guy who doesn't have as much money. If you're Bill Gates and you invest $1 million into a deal and you lose it, what's the big deal? You've got bazillions of dollars. And if you invest 50 grand and you make 250, it's not the end of your life. It's not like you're making 35 grand a year and this is your life savings, and because you lost it, now you're completely gutted for the next 20 years. That's theoretically what it is, but you're right. I mean, I don't think it's a proxy. There's a ton of arguments that we won't.
Now, wouldn't you automatically though have a presumption of sophistication for B deals if you stop making the income? So for the last 5 years, I was accredited and experienced too. I was actually investing. Now, all of a sudden, for whatever reason, I don't have that income and I don't expect to have it next year either. Aren't I automatically de facto a sophisticated investor by nature of my past?
I mean, I maybe, probably. I mean, I'm not hung up on the sophistication. I mean, you're gonna be representing your sophistication, and I can reasonably rely on that. So I don't put a lot of stock in the sophistication.
Okay.
Obviously, if you're, again, the extreme example, you're the widower and you've never been involved in finances, okay, maybe. But yeah, you would just be sophisticated. You just be non-accredited, especially if you've been doing all. If you fill out that questionnaire that you just saw earlier, you're going to be checking all the right boxes. You're going to be like, your net worth, might not be $1 million, but now it's this, or your income's still high. It's still 150 or 175, or maybe you look at it reverse. My income can be $1 million, but 2 years ago it was 150 grand. Maybe I was whatever, right? So I could be making more money than anybody, but it doesn't matter because I've got to have that consistently over the next 2 or 3. It's a lot of it is BS. I mean, I don't have an answer to you directly, but that's the theory.
I think there's a lot of people on that cusp, let's say between 150, 200 grand income, that are very smart people, but they don't hit that 200. And I'm just trying to think about that little niche. They're not the guy making $35,000 a year. They're making
they're just not
180 grand a year.
They're not making 200 grand. It does, that's why, maybe they should go get it if they're really serious, and maybe they take the Series 65, which is a pain. I get it. And it's a little bit of money, but, or hopefully these new rules will pop out and the SEC will finally release these certification programs so they can take an exam. But right now it is what it is,
If you take the Series 65 though, as I understand it, it's not simply a matter of taking the test and passing. Then you got to go get someone to hang your license somewhere. And why would they do that?
They wouldn't. So you create your own. That's the way you do it, is you create your own investment advisory firm, and then you hang your license into your own firm. Now it's a little bit more complex. So you're probably going to hire a consultant or somebody to help you through that process. But that's what people would do, is just create your own. It's not that complicated from a mechanical standpoint. You create an LLC, and that's your investment advisory
Can you
firm.
take 2 minutes and just talk about that?
I don't know if you've seen my report. I did a Series 65 report. It's on the Facebook group somewhere. But that's the biggest part. So passing the exam isn't a big deal, but then you've got to register in your state. So if you're in the state of California, you have to have an investment advisory firm. And you're right. Why would they? They want you to go sell and advise on their stuff, not somebody else's stuff. But you would just go through the process of qualifying your brand new LLC that you just created yesterday, and go through. And I don't know the details of how the mechanics of how to get that registered, but that's how you would get that registered, which it's got some compliance. It's not impossible. It's not crazy, but get that in the books. And now you can hang your license under your own advisory firm. I don't know if there's anybody, maybe we should ask, you know what, why don't we ask that in the group? See if anybody, I've had a couple, I know, I don't know if Jeff has one, but maybe we should ask that in the community. If anybody has registered an investment advisory firm, maybe
And
Hunter
that's
Thompson did
state-
one.
That's state-based or?
Yeah, it's
federal?
state. It's whatever state you're in, which I forget where
And
you're
can
at.
you only operate in that state then?
Yes, but when you're doing yes, my understanding would be yes, you're licensed in that particular state. You're not at the SEC level. So wherever that chair is where you're located right now, whatever state that's in, that's where you're going to be.
We're talking
advising.
about the investor side anyway. So
Right. So exactly right. So you're not actually going to be practicing.
Right.
So there seems to be an exemption where you can go straight to the SEC level if you're filing for an online advisory. So you're not on a state level. You are straight. Instead of having $100 million assets under management, you can go straight to that level.
Even if you have less than $100 million in assets under management.
Yes.
There you go. Maybe you can post. Do you mind? I didn't know that. So if you want to post that on the group, that would be helpful.
Yeah.
I don't know why. I don't know why you'd want to go. I mean, I don't know what the benefits of going at the federal level, unless you tell me it's easy. I can't imagine doing it at the federal level is easier and less compliant than the state. But maybe if you're in a state like California, maybe it is. But yeah, that's it. My understanding was that it had to be $100 million or more. You weren't even eligible to register as an investment advisor at the SEC level. You had to have 100 million. But maybe there's something I'm not aware of, which wouldn't surprise me. All right, let's see if I got we got quite a few more here. Let me just see if I can wrap it up here. Chris M. Is this the same Chris as before? Looks different. Someone says Dash Los Angeles. Class A member is for LP investors. So there's a syndication that you have Class A members, and then the Class B members are the sponsors. One investor told me they asked how the money is secured. He is a flipper and he wants to lien on the property, but I told him we use a PPM. He is not convinced, but realistically, he is investing in our LLC share. So so the security, I mean, it's even better than, I've had this question before. So if you're a passive investor, sometimes the more unsophisticated ones will actually ask you, how is my money secured? I'm going to invest $50,000 of your deal. Where is the security on that? And my answer to that is, this is not a loan. This is better than a loan because it's not secured. You actually own it, right? You're the owner of the asset. You're not lending and putting collateral on it. So it's actually much more secure. So if for whatever reason, well, first of all, they're just getting distribution. So, but even if they've got a preferred return and you didn't get their preferred return, they're going to own a piece of the LLC that actually owns the property. But it's not a security issue. Now, you could, if you wanted to, have another arrangement, sort of a side deal with that person, say, look, if you lose the money, you could personally guarantee, I guess, where I'm going. You could collateralize some other asset if that's the right. I wouldn't recommend that, but the way these are structured, they're investing as equity. They're members of an LLC. They don't have security in the property. They own the property. If that makes sense. Cedra, hi, Mauricio. I was having problems with attending this webinar with my phone. It is showing blocked. Oh, I didn't know that. I don't know if anybody else has tried to, well, people are calling in. So people call in, it shouldn't be blocked. Shoot me a message on Facebook and we'll figure out the issues there.
Yeah, sure.
oh.
Actually, I used to attend it via phone with the Zoom, but
Yeah.
me and my husband both do, but we both are like, it's showing blocked and we're just not able to get past
Huh.
to join the progressing meeting.
We haven't changed anything. So that's interesting. I'm not quite sure. Let me ask our IT person, see if there's something there.
Much appreciated.
Thanks for bringing that to my attention. Senate, I believe the license has to be active. Yeah, so they has to be in good standing. This is the Series 65, going back to the question. Oh, I have a Series 65, but not my own firm. So is it Senate or Senat? Are you still on? This is good stuff. Are you on, Senate or Senate?
Yeah, I'm here.
Senate. So you have your Series 60. This is great. So you have your Series 65 license.
Yep.
You didn't set up your own firm. So the question would be to echo John's and not a complaint, but something that I've heard many times, although you might be doing it for different purposes, is how did you find a firm to hang your license under without selling or doing whatever they want you to be doing?
I didn't.
Okay.
So I had my Series 65 before because I was an active rep. I actually sold securities and investments.
Got it.
Right. And I actually stopped doing that to move into multifamily because
Right.
most broker dealers do not like it. Exactly.
Yes.
To your point. If you are setting up securities, you're setting up syndications, most broker dealers will not allow you to also sell for them.
Correct.
So my license actually expires in December. And so I will lose that piece of my accreditation. I have it other ways, but I will lose that at the end of December because my license will expire.
Awesome. Anybody have a question for, is it Senate or Senate? How do you pronounce it?
Senate. You got
Senate.
it.
You got like Senate. If anybody has a question on it, I know that it's kind of getting late here, but if you've got a question, there's a good chance to do that. But I guess if you had a sponsoring firm or you were at it, that was probably a little bit easier because I think that's the issue is most people. Yeah. Okay. Got it.
There are a few firms that will sponsor you, but they're all going to want some minimum level of business. They want you to actually work.
Right. Yeah. Cool. Well, thank you, Senate. Appreciate the income. Yeah. Thank you. All right. A couple more, maybe the last one here, which is, oh, here you go. Adam. Also, Adam, my business partner has a Adam, my business partner has a registered advisor firm and it's in California. Total pain to set up. Do you have any other background on that? I mean, I know it's not easy. I mean, that's why, that's why I think most people just hire a consultant and they pay them. It might cost you 10 grand or maybe more these days. Maybe it's more than that, but it's just easier to do it that way. Cause I do understand that it's not a fun thing to do. You got to be really committed. Adam, you have anything to add to that?
I mean, he did it because it's his actual business, but it's constant paperwork. I know California is harder, but that was.
Yeah, it's the compliance, right? It's like, even though you set it up and now you got to, if they have audited financials or, ADV kind of forms or whatever. So it's not easy, but yeah, go ahead.
I did have another question up above there in the chat.
Sorry, did I miss it? I don't know if I got it. I must have missed it. I apologize.
No worries. So you were talking earlier when you were talking to Michelle about verifying accreditation status, and we just use Parallel Markets. And so we just get the letter from them. That's all we need is the letter from Parallel Markets. We don't have to do anything past that, right?
They're a broker, right?
I don't know. It's whatever you wrote. It's what you wrote in the PPM for me to have them go to.
Yeah. So Parallel Markets, I believe, is because the verification letter has to it can be it can be a CPA, which is what most people do. It can be an attorney. I mean, I can theoretically, it's not economical for you to hire an attorney at X amount of dollars an hour to spend, even if they spend 15 minutes on it, it's going to cost you way more than, whatever these other companies do. And it can be an SEC licensed broker dealer. And I think there's one more, or maybe those are the three. So I think, Parallel Market sounds familiar. I think they're a broker, which is why you can get the verification.
Okay.
But once you get it from one of those three, that you don't have to do any, you can rely on that verification letter once you get it.
Okay. Thank you.
Yeah, of course. All right, guys, I think, let me just make sure there's nothing else here. Next week, I also have someone who licensed, but I don't have a firm. Yeah. So, well, thanks again for sticking by. Next week, we're actually going to do an update on the finder rule, which is actually going to solve a lot of our issues. Interestingly enough, even though the SEC has not provided any updates in almost a year and a half or so, there's a bill in Congress that is basically trying to do exactly what the SEC is kind of sitting on their butts on. So we're going to go through that legislation because there's a lot of updates that are making their way through Congress. And if those become law, then we don't have to wait for the SEC to do anything. So I'm kind of excited about that. So I'm going to do a deep dive on the current legislation, and we'll do a quick update next week. And then, as I mentioned before, that week following that, we've got Brandon Turner, who's going to join us and help us on what he's been up to. And he's been crushing it, raising, I think, over $100 million here the last 12 months. So that should be fun. And thanks again for everyone sticking around. I always appreciate you guys, and we'll see you next week.